It's a celebration of America's freedom. Welcome to the Mark Corinne Show. The Mark Corinne Show is your place for a weekly discussion on making America great again. The important political and legal issues of the day, a celebration of the Constitution, and traditional American values. Mark is a practicing attorney, a former senatorial candidate, a Donald J. Trump-endorsed delegate, and a defender of the Constitution. His goal? To put America first. And now, celebrating America's freedoms, here's attorney Mark Corinne.
Well, welcome to the Mark Corinne Show. This is your place on the dial for constitutional conservatism. This is the place where we put America first. And we discuss the important political and legal issues of the day through that perspective. And you're welcome to check out the markscorineshow.com website for some interesting merchandise. And I want to thank my friends and followers on the Mark Corinne Show Facebook, and also Harrisburg 100 Facebook is joining us live today. So if you're a friend or follower of Harrisburg 100, you can follow along and watch the Facebook Live presentation of the show. And you can comment live, and we'll try to respond to some of your comments if I can work all of this technology. Well, I have submitted my biweekly column to Penn Live and the Harrisburg Patriot News, and that will recite that, and that'll be the opening argument for today's show. And then I'll invite my listeners to call in and rebut the arguments I make, or perhaps agree with the arguments I make concerning the plea and sentencing of Donald J. Trump's former lawyer and confidant, Michael Cohen. So we'll start off the show that way. The Office of Special Counsel, working closely with the United States Attorney for the Southern District of New York, has used President Trump's former lawyer, Michael Cohen, to draw presidential blood. They've directly implicated Trump in their criminal case against Cohen for violating federal election law. And former FBI Director James Comey, he said in response to the plea and sentencing that Trump is now certainly close to being an unindicted co-conspirator. But did Cohen or Trump actually violate federal election law? By way of some background here, remember it was in the fall of 2016, as the presidential election contest was barreling toward its conclusion. Trump instructed Michael Cohen to take care of some claims that had been raised by Karen McDougal, a former Playboy playmate, and Stormy Daniels, the adult film actress. These women have been shopping around stories about alleged trysts with Donald Trump from many years ago when he was a private citizen. They were shopping these stories around to the tabloids about these alleged affairs, obviously in exchange for cash. And if Trump wouldn't pay, they would go ahead and speak, and they would speak publicly about these alleged affairs. And this was in the run-up, in the weeks preceding the 2016 general election. So Michael Cohen set up two companies through which he would purchase the rights to a non-disclosure agreement that McDougal had signed with the National Enquirer, and a company through which he would pay Daniels, Stormy Daniels that is, in exchange for her signing her own non-disclosure agreement. And by the way, that non-disclosure agreement and its enforceability or invalidity is the subject of the lawsuit between Stormy Daniels and Donald Trump, in which Stormy is represented by Michael Avenatti. In any event, Cohen made the payment to Daniels and was later reimbursed by the Trump Organization. Now, the McDougal matter, that fell apart when the National Enquirer informed Cohen that the deal was off. All right, so months later now, so we have the election, Trump wins, and months later, prosecutors discovered evidence, prosecuting Michael Cohen as a result of this fake allegation that the Trump campaign was somehow involved with the Russian government or Russian operatives to collude, which is not even a word in the criminal code, to interfere in the 2016 presidential election. So that was the investigation, directed by FBI Director Comey at first, and then subsequently the special counsel. But in any event, part of the evidence that was obtained, recall prosecutors or agents raided and searched Michael Cohen's apartment, his hotel room, in New York, and his law office, and found a bunch of evidence and got the Southern District of New York U.S. Attorney's Office involved. So that's a bit of the backstory there. But in any event, prosecutors discovered evidence of these hush agreements or settlement agreements, whatever you want to call them, non-disclosure agreements, including recordings Cohen had made of telephone conversations with then-candidate Trump about these agreements. Subsequently, prosecutors in the Southern District of New York brought a variety of charges against Cohen, bank fraud, tax fraud, etc., but also 2 election law charges against Michael Cohen, claiming these payments were unlawful campaign expenses because the amounts exceeded the lawful limit. One was $150,000, the other was $130,000, and interestingly, only one payment was made. In any event, the amounts far exceeded the lawful limit to what a person is permitted to donate to a federal campaign or provide via what's called an in-kind contribution to the campaign. And secondly, these payments were made from corporations that Michael Cohen had set up, actually limited liability companies, but in this particular case, we'll just refer to them as corporations, and corporate donations are prohibited under federal election law. So those were the 2 violations charged against Cohen. The violation that corporations are prohibited from making in-kind contributions and donations to campaigns, and the other violation that the amounts, $130,000 and $50,000, far exceeded the very low limits that are permissible for donations or in-kind contributions to federal election campaigns. All right, so that's a little bit of the federal election law and the violations as charged. Now, the indictment states Cohen caused and made the payments in order to influence the 2016 presidential election. And remember, the prosecutors, when they had Cohen in court, when Cohen was giving his guilty plea, they had Cohen say under oath the payments were made in coordination with and at the direction of a candidate for federal office. Now, of course, that person is otherwise known as Donald J. Trump. And Cohen continued, I participated in this conduct for the principal purpose of influencing the election. Now, those words, principal purpose, those are the magic words by which the government has transformed these otherwise lawful payments into a crime. But are those words true, the words spoken by Michael Cohen, that the payments were made for the principal purpose of influencing an election? Recall, prosecutors were zeroing in on that express language. They made sure that they had it in the indictment document that was filed with the court, and that they had Cohen state it under oath when he presented himself before that judge for the guilty plea that occurred back in August. We'll talk more about the Michael Cohen sentencing and its effect on President Donald J. Trump when we return from this brief commercial break. You're listening to The Mark Scaringi Show.
Let's get back to The Mark Scaringi Show on News Radio WHP 580.
And welcome back to The Mark Scaringi Show. This is your place on the dial for constitutional conservatism. This is where we talk about the important political and legal issues of the day from the perspective of putting America first. We're talking about the guilty plea and sentencing of Trump's former lawyer and confidant, Michael Cohen, and its effect on President Donald J. Trump. And we're kind of getting into the weeds a little bit, so I apologize, talking about the indictment that was filed against Cohen, the guilty plea allocation that occurred by Cohen to the judge presiding over the acceptance of his plea. Now, that occurred back in August, and I'm talking about to what lengths the prosecutors made or went in order to ensure they got these magic words on the record that, according to Cohen, the payments were made for the principal purpose of influencing the election. And I am presenting to you some doubt that those words are true. If Cohen used this money, let me give you an example, to purchase a Trump for President yard sign. Now, do you agree, and I'm talking to my listeners out there, do you agree that that would clearly be for the principal purpose of influencing an election? If you read the yard sign, it says Trump for president. A reasonable person could conclude the purpose and the principal purpose of the purchase of that yard sign was to elect Donald Trump, and that means influence an election. So that's a pretty easy, clear-cut case. Right now, in this case, Michael Cohen used the money, $130,000, $150,000, to obtain 2 non-disclosure agreements. And the non-disclosure agreements were about things that occurred years before Trump was a candidate for political office. The non-disclosure agreements had nothing to do with the Trump presidential campaign that in fact did not exist at the time of the alleged acts that precipitated the non-disclosure agreements. There's nothing in the non-disclosure agreements that reference a campaign, a political election, a candidacy, or anything like that. So if you read the non-disclosure agreement, can you ascertain the purpose of the non-disclosure agreement? I think you can. I think if you read it, it says, well, these are payments being made in exchange for silence. That's the purpose of the non-disclosure agreement. If you look at a yard sign that says Trump for president, can you ascertain, a reasonable person, you're all reasonable people, my listeners, of course, can you ascertain the purpose of the yard sign? Well, yes, it's to elect Donald Trump president. It says it right there. So those are 2 examples that I'm giving to try to illustrate why a non-disclosure agreement that has nothing to do with a campaign, has nothing to do with an election, has nothing to do with acts or incidents or situations involving a campaign or a candidacy, is just simply not a campaign expense. I mean, it's not done for the principal purpose of influencing an election. It's done for the principal purpose of obtaining the silence, which is the purpose of the agreement. I mean, it's pretty clear to me, but not to the prosecutors in the Southern District of New York, nor to the judge presiding, who accepted the plea and issued the 36-month sentence, well, it's the same thing, on Michael Cohen. Now, I'm talking a lot about this principal purpose, and by the way, as I say, so were the prosecutors, because the leading case, now, of course, the statute are members of Congress whom we elect to represent us and to write rational, clear laws that are easy to read and easy to understand, right? That's why we elect them. Well, have you ever read the Federal Election Campaign Act? I would not recommend it to my listeners. It is a morass of vagaries. And in any event, of course, the statute, the Federal Election Campaign Act, does not define influencing the election. Wouldn't it be nice if there were a definition? But of course, members of Congress, of course, I mean, they don't think about the implication of these laws on the American people and people who are trying to follow them. In any event, the statute has no definition, so we look to case law, and we ask our judges to interpret these statutes so that we can be governed by them. And of course, when you have judges interpreting statutes, we've got lots of judges. We have 67 counties in Pennsylvania. We have 3 federal judicial districts in Pennsylvania. We've got tons of judges, and judges decide things differently. You ask 2 attorneys for their opinion on the same legal matter, you get 2 different opinions. You take your case to one judge, and you get a different opinion than you might have received had you taken your case to a different judge. But in any event, the leading case, ironically, comes from the Second Circuit Court of Appeals. The Second Circuit Court of Appeals covers the jurisdiction in which Michael Cohen is being prosecuted. So one would think that the Second Circuit Court of Appeals and what it says about the definition of purpose of influencing the election has binding, controlling authority over that trial court that accepted Cohen's plea. And the Second Circuit Court of Appeals, in a case back in the 1970s, was examining an ad placed in the New York Times in May of 1972, a presidential election year. Remember, President Nixon was up for re-election. That ad called for the impeachment of President Nixon. Listed in the ad were congressmen who had voted for impeachment and stated it would devote its resources in funds and publicity in aid of any new candidate for election or re-election who supports the impeachment of President Nixon. The ad even included coupons. So if you're a reader of the New York Times and you get the New York Times and you read the ad, and if you want to donate to that organization, that group, that political committee that was formed and ran the ad for the purpose of impeaching the president, and you wanted to donate to that group or the congressman it was pledging to give money to who supported impeachment, you could tear off a little coupon and send that in with your donation so that those congressional candidates up for election or re-election could receive your donations from this ad. So that sounds pretty election-y, doesn't it, to use a non-legal term? In any event, the government in that case was arguing the purpose of the ad was to influence the election. What do you think? Is the purpose of that ad to influence the election? Call in and let me know, 717-540-0580. That's 717-540-0580. Let me tell you the answer. The court, however, ruled the advertisement seeks support of an impeachment resolution, not the election of political candidates. As such, the purpose of the advertisement was at most only incidentally to support candidates and engage in political activity. The court reached that conclusion how? By reading the ad and interpreting and deciphering the words of the advertisement. And they read it and said, oh, this is about impeachment. It's not about influencing an election. Think about that. That's the case from the Second Circuit Court of Appeals that has binding and controlling authority over the Michael Cohen plea and sentencing. Compare that to the non-disclosure agreements. The money in the Cohen case was used to purchase non-disclosure agreements. Read them. Do they talk about influencing an election? No. Not a word. They're about purchasing silence. Nothing to do with influencing an election. Think about that. Donald Trump, then a candidate for the presidency in October or November, whenever he was talking with Michael Cohen about these settlement agreements, he may have had various reasons or motives why he instructed Michael Cohen to make the payment, including protecting himself and his family from humiliation, from embarrassment, and even protecting his campaign from embarrassment and scandal. But those are motives why someone does something. Since when is motive an element of a criminal offense? As a young attorney, I'm not so much a young attorney anymore. When I started out doing criminal defense work, I can remember the prosecutors, the assistant district attorneys here in central Pennsylvania, who are all outstanding and excellent attorneys, saying to me, well, I don't have to prove motive. Why are you asking me? Why are you pointing out that your client had no motive to commit the offense? I don't have to prove motive, the district attorneys would say. Well, that's right, because motive is irrelevant. It's not an element to the criminal offense. So Trump may have had a motive to order Cohen to make the payments and make the deals to protect his reputation from embarrassment, even protect his campaign from scandal, but those are motives. And as the Second Circuit Court of Appeals And if you look at the dictionary, you may see that motive is a synonym for purpose. And the Second Circuit Court of Appeals was saying there can be many purposes, many reasons why we do something. But in interpreting the Federal Election Campaign Act, you have to prove that the expenditure was done for the principal purpose, the principal aim or thrust, according to the court, was to influence the election. And that certainly, in my view, did not occur in the Michael Cohen, Donald J. Trump case. We'll talk more about the Cohen sentencing and its impact on President Trump when we return from this brief commercial break. You're listening to The Mark Scaringi Show.
Now, more of Mark Scaringi on News Radio WHP 580.
And welcome back to the Mark Scaringi Show. This is your place on the dial for constitutional conservatism. This is where we talk about the important political and legal issues of the day from the perspective of putting America first. We're talking about Michael Cohen, President Trump's former lawyer and confidant, who has pled guilty and now has been sentenced on a variety of crimes, including 2 election law violations and their implication on President Trump. And we're breaking down the case and talking about some appellate or one appellate court decision, and which has controlling authority over the Michael Cohen case, and how it interprets the Federal Election Campaign Act that Cohen has pled and has now been sentenced to, is really looking for the principal purpose of the act must be to influence the election in order to sustain or be a violation of the federal election law. And I'm pointing that out, and for the purpose of our discussion here today, and you're welcome to call in 717-540-0580, and let me know your thoughts on this very important issue, because our friends in the media and the Democrats in Congress are now using the Cohen sentencing and its implication that Donald J. Trump is a co-conspirator in this felony, this federal election law violation, which is a felony under federal law, to serve as grounds and a basis to bring impeachment proceedings against the president. And of course, the president could and does face criminal charges, or could face criminal charges, and does face criminal liability for what he was doing there with Michael Cohen. Now, I do want to point out that the Department of Justice, by the way, has already been down this road before. The Obama Department of Justice brought a criminal case against former presidential candidate John Edwards. It claimed he orchestrated, Edwards that is, payments from 2 of his maxed-out campaign donors to be used to hide his then-pregnant mistress at a critical stage in his campaign. And prosecutors argued those payments were campaign expenditures because they were made for the principal purpose of influencing the election. Now, they were illegal, allegedly, because those 2 donors had already maxed out on their donations to the John Edwards for President campaign. So the in-kind contributions made by those donors to pay the hotel bills and restaurant bills of Edwards' then mistress, I forget her name, were unlawful because they were in excess. They were above the lawful limit. So, nevertheless, the Department of Justice lost that case. They did not get a guilty verdict on that question. And the Department of Justice in the Cohen case is arguing the same position. However, unlike Edwards, Cohen has pled to the offenses, and the judge accepted his plea. Now, of course, Cohen pled to those charges because he thought he would get a reduced sentence for his actual crimes, bank fraud, tax fraud, etc. So that's why Cohen pled to it, because the prosecutors were so hell-bent on getting those campaign charges in there because they implicate the President of the United States. And that would, of course, then justify this whole endeavor of this investigation of the president and his campaign for collusion and all different kinds of things. But think about the implications of the position now by the United States attorney. And that is, according to the Department of Justice, candidates for federal office must, otherwise they could be charged criminally, use campaign funds to purchase the silence of their mistresses or hide them from media scrutiny. Now, what about those candidates who accept matching taxpayer funds? Do you want Donald Trump using your taxpayer dollars to pay off the next woman who alleges she had an affair with him? Is that how you want your taxpayer dollars to be used? Call in and let me know, 717-540-0580, and we'll get to the bottom of that. And I'll make one last statement as part of my column in Penn Live and the Patriot News, and we'll open the phone lines then, and we'll take some calls. And then as I acknowledge the zeal of the special counsel and prosecutors and our Democratic friends to take down Trump, I get it. But in doing so, they're distorting the law, and they're opening Pandora's box. We now have the legal absurdity of Michael Cohen being sentenced on 2 non-crimes, and the legal and political absurdity of the president possibly being charged with criminal conspiracy to commit the same 2 non-crimes and being subject to impeachment for high crimes and misdemeanors. So there you have it. There's my opening statement. It went a little long, as they always used to whenever I was in court handling criminal cases. So we'll open up the phone lines. We'll take some calls. We have had some comments on Harrisburg 100 Facebook, so you can comment on Harrisburg 100 as well. The first comment, God has the control, amen. Well, let's see how hopefully he does. Another comment from Chucky Henderson. Agent Orange, I guess that's Donald Trump, was good with everything Cohen was doing until recently. Well, true enough. So let's take some phone calls. We have Richard from Mechanicsburg. You're on the Mark Scaringi Show.
Hi, Mark. Love your show. Let's see. Intent. Let's see. As far as I know, only Jesus or God can, know what's in our hearts, and the rest of us have to interpolate or something based on our actions. Now, police often looking into investigations look for means, motive, and opportunity. In this case, let's compare to Comey and Hillary. There was no intent. But Lady Justice has scales and a blindfold. Scales to weigh the actual evidence, and a blindfold so we don't see anybody's position or, what their background is, or color of their skin, or, whatever their politics are. And it seems to me that intent might be when you're looking up to investigating, but then you look for the evidence. And the evidence is what goes to court and gets weighed on the scales of justice. So I don't see that happening in this case at all. I'll hang up and grab the next one. Thank you.
Well, Richard, thanks for the call. I appreciate that, Richard from Mechanicsburg. And you actually, you raise a very interesting and I think a worthwhile point when you talk about when you compare what's happened to Cohen and what will happen to Donald Trump with what happened to Hillary Clinton with regard to the investigation into her alleged misuse or violating our national security laws and the Espionage Act concerning the emails in the server. And in that case, the prosecutor, the investigator, the prosecutor, the FBI, Department of Justice, you don't know, but it was FBI Director Comey who basically was playing both roles in that case, which is unusual and unprecedented, actually, and wrong. But in any event, Director Comey said that, in that case, you didn't have to prove intent. It was actually easier for the prosecutor in that case. All they had to prove was gross negligence in that case. And remember, the FBI investigators and the agents on the case, remember Agent Struck. He's the gentleman who struck out on the initial memo that Comey had written those words and changed them into something like extreme carelessness or something like that, which is essentially gross negligence. It's the same thing, but he struck out the magic words because had Comey included the magic words in his statement, then the statement should have been an indictment against Hillary Clinton, because in that case, all the prosecution had to prove was negligence. Did Hillary Clinton act negligently with regard to the maintenance of her national security secrets? And it's very easy to conclude that she did. She did, because she stored thousands of them on an unsecured server in direct violation of the law. And in this case, the case against Cohen and Trump, the prosecutor has to prove, if you actually follow the law in the Second Circuit, that the principal purpose, the principal aim and thrust, so the principal purpose of the expenditure was for the purpose of influencing an election. That's a much higher burden of proof for the government in this case. Comey says no reasonable prosecutor would have brought the charges against Hillary Clinton. Well, that's laughable, because we've seen prosecutors in the Southern District of New York bring much more difficult charges in the Cohen case, because this is probably a precedential case. You're not going to find any other cases in which candidates have been charged and pled and sentenced criminally for paying hush money to mistresses. A much more difficult case to prove, yet alone. However, we get a guilty plea, and now we get a sentence on it. And we've got some more callers on the line, and so I want to tell you to hold on the line, because we're going to take a brief commercial break. You're listening to the Mark Scaringi Show. Stay tuned. We'll be back right after this.
Now back to the Mark Scaringi Show on News Radio WHP 580.
And welcome back to the Mark Scaringi Show, your place on the dial for constitutional conservatism. We're talking today about the plea and sentencing of Trump's former lawyer and confidant Michael Cohen and its effect on President Trump. And I've read through my opening statement, which is actually my column on Penn Live and the Harrisburg Patriot News. You can get on the Penn Live website and check that out if you want to read it. You can also share and like it if you do. And we're taking some calls and hearing from our listeners to hear what they think about the Cohen case. And we've gotten an interesting call where a very adept comparison was made to the Hillary Clinton case, and how in that case the government only had to prove negligence, gross negligence in that case, but yet FBI Director Comey couldn't find himself to bring charges because no reasonable prosecutor would. However, I guess there are some very reasonable prosecutors in the Southern District of New York who brought extremely difficult and unprecedented charges against Michael Cohen for campaign violations involving payments to Trump's former mistresses that there's no record in the courts that has ever been brought as charges, let alone successfully, with the exception of the somewhat similar charges brought in the case of presidential candidate John Edwards, in which the government ended up losing the case. Nevertheless, here we are. And we will, as I say, we will open up the phone lines and we will take some calls. We have Joe from Pembroke. You're on the Mark Scaringi Show.
Hi, Mark. Great show. I've listened to you for the last 2 weeks. 261 cases of this sort of money being paid to people that have had certainly trysts, illicit affairs, et cetera, et cetera, et cetera. The thrust of your argument, as I take it, is should taxpayer money be involved with this? And I'm afraid that no, of course it should not be. And that's probably only the tip of the iceberg. You have enlightened me. And Mark, what do we do? What do we do to combat? What do we do to combat this? As a voter, sometimes my vote counts, sometimes it doesn't. They're questioning the voting laws. How many times can a person vote? I mean, what can we do to stop the government from doing this? And thank you, sir, for having me on your show. Take care, sir. Goodbye.
Well, Joe from Pembroke, thanks for the call. Appreciate that. What can we do? We can lobby our members of Congress to ask them to change and amend the Federal Election Campaign Act to add to that statute the interpretation that the courts, at least the Second Circuit Court, has determined that the expenditure has to be for the principal purpose of influencing the election. That would add a little stability and it would make the statute more understandable and more relatable to the actual world in which we live. Under this interpretation, and well, actually under the interpretation that the prosecutors and the judge were trying to use in the Edwards case, that any reason if any reason is for the purpose of influencing an election, then the expenditure is a campaign expenditure and must be made pursuant to the limits and governance of the Federal Election Campaign Act. That would be a horrible result if any reason. I mean, every single decision that a candidate for elective office makes is for the purpose of influencing the election. I mean, let's be serious and let's engage with reality. And that's the situation that we are dealing with. Now, one of the president's senior advisors is Kellyanne Conway, and she does a great job defending the president, defending his policies, defending his statements and tweets as well. And, the joke around the Washington, D.C. and around the country now is that her husband, George Conway, who's an attorney, a purported Republican, has just very publicly challenged the president on a variety of situations, on various statements and tweets and decisions the president has made. George Conway has become his nemesis, so to speak, and it's a little odd in that he's married to the president's senior advisor. But George Conway and some others wrote a piece in the Washington Post, and they were talking about the former Senator John Edwards trial when he was put on trial for similar crimes, and how his attorneys repeatedly argued the payments were not campaign contributions. They were made because they were not made exclusively to further his campaign. In that case, the judge disagreed and rejected this argument as a matter of law, ruling that a payment to a candidate's extramarital sexual partner is a campaign contribution if one of the reasons the payment is made to influence the election. And that's the absurd legal result we got from that judge and those prosecutors in that case. The jury didn't buy. If that same candidate, John Edwards, who was orchestrating payments to his ex-mistress, or his current mistress at the time, who was pregnant, to hide her from the media and thus, to make her life easier, then I wonder if payments that he made to his wife were also campaign expenses. So if he bought his wife a new dress, if he bought his wife a new ring or engagement earrings to make her happy so that she wouldn't run to the press and say, oh my goodness, my husband John Edwards has just committed an extramarital affair. So are those payments that John Edwards may have made to his spouse at the time, are they campaign expenditures? Must they be reported on John Edwards' campaign and election reports? I don't know. And because that judge in that court declared that if any reason is to influence the election, the campaign must be reported and it must be used with campaign expenses. And they must, of course, apply to the Federal Election Campaign Act. And that's, as I say, that's an absurd legal conclusion to draw. But nevertheless, that's what we're getting when we have Michael Cohen plead this way and judges accepting that plea. We get these absurd results. Now, Michael Cohen did a big interview the other night with George Stephanopoulos that is generating a lot of media attention. And in the interview, Cohen said that the president's repeated assertion that Cohen is lying about the payments and other aspects of his work for Trump were false. Cohen says he knows the truth, meaning Trump. I know the truth. Others know the truth. Cohen said the man doesn't tell the truth. And it's sad that I should take responsibility for his dirty deeds. All right, so George Stephanopoulos asks the big question. Stephanopoulos asks Michael Cohen in this interview on ABC, I think that was last night it was aired. Stephanopoulos asks, Trump says he never directed you to do anything wrong. Is that true? Answer by Michael Cohen, I don't think there's anybody who believes that. And then Cohen answers again saying, he directed me to make the payments. Now, the question was, did Trump ever direct you to do anything wrong? The question should have been, did Trump ever direct you to break the law? Because that would have been the more appropriate question. Now, why didn't Michael Cohen say to President Trump, when President Trump said, hey, Michael, take care of Stormy Daniels and take care of Karen McDougal. Give them what they want to keep them quiet. That's probably the words that were used or something similar to that. Why did Michael Cohen say in response, Mr. Trump, if we pay hush money, if we enter into a non-disclosure agreement with Stormy Daniels or Karen McDougal, that will constitute a campaign expense. And as such, we can only use campaign funds to do so. Otherwise, we're violating the law. Or, Mr. Trump, you can make those payments directly, but we have to report those payments on our campaign filing forms because those are expenses made for the purpose of influencing the election. And maybe Trump would have said, oh my goodness, so what you're telling me is this whole situation that you have created, this whole structure for handling this situation, Mr. Michael Cohen, my attorney, what you're saying is if I do this, I'm committing to felonies. I'm committing to Federal Election Campaign Act violations. That's probably what Trump would have said, and Cohen would have said if he were properly advising the client, he would have said it's quite possible that a vigorous, zealous prosecutor could argue that these hush money payments are in fact for the principal purpose of influencing the election, and you and I could be charged criminally if we don't handle this pursuant to the federal election campaign laws. But of course, none of that was discussed. None of it. And Cohen, I'm sure, didn't present that to his client. So the client is kind of following what his lawyer is suggesting or saying about how this can be handled. You know, did George Stephanopoulos ask Cohen if Cohen had instructed Trump that by making those payments in the manner in which they structured, it could be considered illegal? Probably not. Did George Stephanopoulos ask? Well, we know George Stephanopoulos didn't ask him the question because you've got a media celebrity asking questions about legal issues, not lawyers. And so you have like a media celebrity response. Oh, it was wrong. Well, you know, it may have been wrong in the sense that it wasn't. I'm not sure how it's wrong. If it's not legally wrong, maybe it's morally wrong, I guess. But it certainly, in my view, wasn't legally wrong, although the judge presiding over that case in New York had a very different opinion of that. And that's the risk we run in these cases. But the interview by George Stephanopoulos didn't really reveal anything substantive. It just revealed this kind of vagueness about moral wrongs that have now been converted into criminal wrongdoing. So that's the ABC News interview with Michael Cohen. Now, of course, our friends in the media are calling this the end stage of the Trump presidency. That's according to the New Yorker. Michael Cohen in the end stage of the Trump presidency, and I have very real fears, and I think they're based in reality, and they're reasonable and rational, and that is you're going to be seeing a sitting president of the United States being indicted, and you're going to be seeing the House of Representatives bringing impeachment proceedings against President Trump. That's all the time we have today for the Scaringi Law.
Hi, this is attorney Mark Scaringi. Every Saturday afternoon at 1, thousands of central Pennsylvanians listen to the Mark Scaringi Show on WHP 580. It's a program about state, local, and national politics from the point of view of putting America first. If your business or organization would like to reach my listeners, you can advertise on my show. Promote your business on the only weekend political show in central PA. Call 717-657-7770 and talk with Jason to promote your business on the Mark Scaringi Show.